In Powers versus Katia, the question in this case is whether the plaintiff can get in certain documents from services that the landlord had performed on the rental property. So in this case, the plaintiff had complained about various things being wrong with the apartment, namely that there were birds that were nesting outside of the apartment window, and the plaintiff or the landlord didn't do anything about it. And a year later, there are bird mites in the plaintiff's apartment. So she has to move out. She sues the landlord for damages and to get her security deposit back. And the question is whether she can admit certain documents that show the extent of the work the landlord had to do to repair the property. So she wants to bring into evidence invoices from work that the plaintiff, or rather that the defendant landlord, had done. So the theory she tries to bring in these invoices under is that these are statements of the defendant's agents or employees. So the question then becomes whether the various cleaning companies that came in, whether they are within the meaning of 801 D2D, whether these statements were made by the party's agent or employee or on a matter that was within the scope of that relationship and while it existed. So the question then in the Powers case is whether these various cleaning companies were independent contractors or whether they are employees. And so the court looked at comparable circumstances with cleaning companies and said that the Rhode Island courts had never previously held that people who do that sort of work would be regarded as employees of the folks who hired them. So the nature of 801 D2D will send you to employment law questions. Is someone an agent or employee, or is someone an independent contractor who has considerably more volition over his or her activity? And therefore, when that person would speak on the nature of the work being done, they wouldn't be regarded as speaking on behalf of the principal, on behalf of an employer, but rather the work would be done sufficiently independently that statements about the work we wouldn't attribute back to the person who hired the work done. So 801 D2D is entirely a case about employment law. And depending on what side of the employee independent contractor you fall on, the employee / agent, those statements are attributable back to the principal if made within the scope of that relationship. If, however, our traditional notions of employment law would cause us to conclude this is an independent contractor, then statements about the work done would not reflect back to the principal and would therefore not be admissible under this particular version of the party admission.